Welcome to the Southwest Florida Real Estate Update, hosted by the York Group of Downing Fry Realty. Our show will bring you the most up-to-date information on the local real estate market, presented by leading experts in the field.
Welcome to the Southwest Florida Real Estate Update. I'm Morgan York with the York Group of Downing Fry, and today we're joined with our host Jim York and his guest Donald Ross Jr., President and CEO of Ross Title and Escrow.
Thank you, Morgan, for the introduction. Well, Don, thanks for coming on the show today.
Thanks for having me, Jim. Always a pleasure.
I know. So tell the people a little bit about yourself.
Well, I'm Don Ross. I'm a local Naples attorney. Been here since the 80s. Specialize in real estate closings. I am one of the owners at Downing Fry Realty, so I get to hear a lot of the in-house issues that the agents have, get exposed to all the lawsuits, all the ethical claims, things like that. I own Ross Title and Escrow. We've been around for decades. Do quite a few closings, have a team of 8. Ladies have been with me. Janet's been with me 35 years, and then I have her daughter of 25 years and her sister for, gosh, if I don't get this right, I'm in trouble.
Right.
But it's 15 years, I think, or then her daughter and a few other folks, all good people.
You got a great team, and they
Thank you.
return phone calls like yourself, so that's why we use you.
Thank you.
So
you got to return calls.
Don, let's go over this contract here about people losing their deposit if they mortgage contingencies, and
Sure.
just briefly go over that.
Well, this is the statewide contract, lovely document put together by the Florida Association of Realtors and the Florida Bar. This has been around, this particular one, since 1973, not in this form, but
Right.
the basic FAR Bar since that time. It is the only contract, by the way, NABOR FAR Bar, that actually requires a seller to spend money to fix things. So it's useful for agents, I think. I think it's overlooked. I mean, it's a lot to it, to master it, but if you want a contract that will force the seller to spend a certain amount of money to fix certain things as defined in this contract, you might want to explore this.
It's a percentage, right?
It's percentages, general repair items, wood-destroying organisms, and permits. But the consequences of it going over vary. So, I just, and I'll get in more to it, I guess, with realtors later. But it's the only one where the seller has to. I mean, with the as-is contracts, both Naples one and the statewide one, the seller can say no. And in the standard Naples one, the NABOR one, the seller can still say no. So this one, they don't have any choice. You could actually enforce it in court if you needed to. I mean, there are things they miss that we have to take care of in other ways, but it is the one that can basically shove it down somebody's throat, for want of a better metaphor.
Well, then let's just talk about the mortgage contingency.
The mortgage contingency, I must say, I dislike with a flame, if that's...
So no contract's perfect, right?
No. I mean, you got to be really careful. This was changed recently, and the problem, this is the one contract where if the buyer doesn't do something by a certain date, there's a provision in it, and it's in paragraph 8 in the contract, that there'll be deemed loan approval. So the buyer is given 30 days to apply and give notice to the seller that he has loan approval, or if he doesn't have loan approval, to terminate the contract or to waive the loan approval contingency. 30 days. And if he doesn't give that notice, automatically he's deemed to have been given loan approval, which is scary.
Right.
And with a Naples contract, we have our financing contingency where the buyer, after I think the default period is 45 days, may waive the financing contingency, and if the buyer doesn't waive it, then other things happen. But the buyer has to definitively do something in order for there to be a waiver. This one, you get deemed loan approval if they do nothing. So whenever I get a realtor who's using this, which has a lot of good things to it, I always tell them, take the 30 days, that's when the default period is for deemed loan approval, and encounter, say, 1 week before, where you check with your buyer and say, are you okay with your loan? Do you have backup money in case the bank isn't able to close? You don't want to be scrambling around on the 30th day, trying to reach your client and potentially not reaching them and having it pass, and then you have deemed loan approval, because at that point it's like a cash contract with certain minor ways out. So anything that happens automatically makes me nervous. I mean, it's hard to get people to read. I mean, you look how thick the thing is.
I know.
I mean, it's, how many pages? Oh gosh, I mean, it's 11 pages, and that's without the addenda. So if it happens automatically, you just have to really know that's there and be careful with it and talk to people a week before the 30 days runs out. If the interesting thing, and I think your question was, if you go past that loan approval period, is the buyer's deposit at risk?
Right.
And if the buyer did not give notice of he's waiving the loan approval period or he's terminating the contract, he actually can terminate the contract. The buyer can potentially get his money back if the appraisal comes in low, that's in there, even though he's given notice of loan approval, or property-related conditions in the loan approval, whatever the heck that might be. They might have some requirement that something be repaired or fixed. An interesting case came out last year, Lafont, I think it is, where the contract called for the buyer to borrow roughly $400,000, 30 years at a fixed interest rate. The buyer on their own went and applied for a loan different than what's in this contract. It was an interest-only loan for 1 year. Better deal, better rate. The appraisal came in $160,000 low. And that normally would be one of the ways for the buyer to get his deposit back. The court, because the buyer went ahead and applied for a different loan than was in the contract, said, you're out of luck. You cannot use that appraisal provision because that deemed loan approval language in this contract is, they call it a legal fiction, which is, we're making believe you approved it, even though you really didn't. For purposes of this document, we're making believe you waived it. Well, we're not going to play make-believe if you went and changed what kind of loan you're going to apply for. And so in that case, the client lost his deposit. So to go back to your question, is his deposit at risk if he gives notice of waiver of loan approval? The answer is maybe. I mean, if he gets an appraisal that's too low, his deposit shouldn't be at risk. If it is a property-related condition that was involved in the loan approval, it should not be at risk. Otherwise, it is. And I always, when I go over this with the clients, you get into a whole thing. Is it a local lender? Is it an out-of-state lender? Have you worked with them before?
Exactly.
If it's an out-of-state lender, depending on what part of the country it is, they don't have time is of the essence in different parts of the country. That, you sure you have backup money in case this bank is a week late, especially during COVID?
That's right.
Do you have money that in a pinch you could get your hands on if the bank is, say, 1 week late? So I do my darndest to protect the people in that situation, and I try real hard to, at least with the realtors, they can call me, I give them my cell number, talk to them the week before, do they have backup money? And so to answer your question, sometimes it's at risk.
I think you covered it pretty well there.
It's a complicated clause.
It is, and I think
really
sometimes that's why I recommend trying to deal with a local lender, and because the appraisals, the guy with the virus and everything, some of them don't want to come in the house, or they're not getting a good appraisal. But and I also recommend talking to you about the contract too. So which from a legal standpoint, even though we know a lot about it, we've been doing it 20 some years here in Naples, but you a little bit longer. So. But Don, thanks for coming on the show today.
Always a pleasure,
You did
Jim.
a wonderful job like usual, and we'll see you next month, right?
Yeah, absolutely.
Okay, thank you.
Take care.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Looking for a real estate closing agent in Southwest Florida? Ross Title and Escrow has over 25 years experience and has closed over 20,000 residential real estate transactions. Donald Ross Jr., president of Ross Title and Escrow and a practicing attorney in the state of Florida with a degree in taxation, is here to service your needs. Call Mr. Ross or one of our 4 closing agents for a free consultation today.